Hi, I'm Lisa Fong. This is our short hearing tip number 1 on hearing panels and conducting a check to avoid conflicts of interest. If you haven't viewed our introduction to the 6 hearing tips we will be posting, please go to our blog at www.ingariss.com/blog to view the introduction. When a hearing panel is formed for a hearing, it is important that a check be done to identify any conflicts of interest or apparent conflicts of interest. If a check is not done, then the panel runs the risk of finding out one or more of its members are in a conflict at the commencement or during the hearing. This can result in the panel having to end the hearing and commence a new hearing later with a new panel. Having to reorganize for a new hearing to take place takes time, is costly, and can be prejudicial to the respondent registrant who has already likely had to wait for some time for a hearing to be scheduled. So it is a best practice to conduct a check for conflicts of interest from the outset. One of the questions I often get is whether a new member can be parachuted into the panel if a conflict is identified so that the hearing can proceed. One of the main principles of administrative law is, he who hears must decide. This means that hearing panels who hear the case decide the case. So it's not normally possible to parachute a new member into the panel if they will only hear part of the case, but still be expected to make a decision on the whole case. Now, having said this, there are always exceptions in law and various circumstances that might lend themselves to other legal solutions. So if this situation should occur in the middle of a hearing, the panel should get advice from its independent legal counsel and hear what the parties have to say. Now, moving to conducting the check for a conflict of interest. First, review the committee's conflict of interest policy to remind yourself what a conflict of interest is and what an apparent conflict of interest is. Second, contact each of the panel members to ascertain if the member knows or has a relationship with the respondent registrant, and if so, ascertain the nature and the extent of that relationship. Discuss with the member whether that relationship would mean that the member could not be independent or appear independent. If there is an actual or apparent conflict of interest, then the member should not form part of the hearing panel. I always recommend erring on the side of caution. If there is some sense that having a particular member on the panel could result in a challenge to the panel's composition or the panel's decision, then it is better to avoid the anticipated problem. Now, 3. If your profession has a small membership or the case concerns events in a place with a small population, consider conducting a conflict of interest check against the party's witnesses. You won't likely be able to do this when the panel is being established, but you should be able to do this well before the hearing. This can be particularly important in cases involving standard of care issues where there will be expert witnesses from the profession who panel members may know personally or professionally. To do this, just ask the party's counsel for a list of their witnesses with the understanding that the disclosure of the list is only for the purposes of checking conflicts of interest. I hope this first tip was helpful to you. Thank you for viewing.